Thank you all for your patience and indulgence. It took a little longer than we planned. The committee will now resume, and our next questions will come from the gentleman from North Carolina, Mr. Harris.
Thank you, Mr. Chairman. Thank you all on the panel for your patience today and continuing to persevere as we go through this day. Speaker Gingrich, you've referred to this trend we're discussing today as a, quote, emerging dictatorship of district court judges, end quote. And you posted on X that the No Rogue Rulings Act, quote, would be an appropriate first response to the district judges who are trying to be mini presidents totally beyond their constitutional authority. I totally agree with you, Speaker Gingrich, and the No Rogue Rulings Act would be an impactful first step in addressing this problem. I was proud to vote in favor of it when this committee marked it up, and I later joined on as a co-sponsor and look forward to at some point having the opportunity to vote on the House floor. But Speaker Gingrich, specifically, do you believe there are any additional legislative steps that need to be taken to address the problem of activist judges acting beyond their constitutional authority as you described in your post?
Well, I would just say for the moment that this issue of district judges becoming alternative presidents and issuing nationwide injunctions is such a central point to where we are, that solving this, first of all, if we can successfully limit the district judges, we will have sent such a strong signal of rebalancing the Constitution that I think it will sober up everybody in the judicial side. I mean, in the future, there are some key issues. The whole notion of whether judicial supremacy means supreme inside Article 3 or supreme over Article 1 and 2, I think is an issue worth taking up. But I would put that at a very distant second to solving this immediate problem, because if you solve the immediate problem, you both make it possible for the executive branch to be effective, and you've sent a pretty powerful rebuke to the judicial branch that they can't overreach in what they're doing. So I would make it a sequence in that sense.
I got you. Well, as we all know, President Trump issued an executive order 14160, which was referenced earlier today, in ending birthright citizenship for children born to illegal immigrants or those on temporary visas. It was on February 5th that U.S. District Judge Deborah Boardman of the District of Maryland issued a nationwide preliminary injunction against this executive order, arguing that it ran afoul of the 14th Amendment. Speaker Gingrich, do you think it is in line with the president's duties to re-examine birthright citizenship as he did with Executive Order 14160?
Well, I mean, it's certainly a legitimate function of the presidency to look at how things change and how they evolve. I suspect in the short run, this will be resolved at the Supreme Court level. And I personally believe that it's pretty hard to go back and look at the debate at the time of the 14th Amendment was adopted and somehow leap from that to a birthright situation. And in fact, they're fairly clear, for example, that people who are born to diplomats in the United States do not count as citizens. And there are other factors there, but I think the next phase of that argument is going to be at the Supreme Court level. And then I think, depending on what happens, you know what, we live in a very different era. The scale of illegal immigration, which frankly has changed. My guess is some of these debates will change pretty dramatically because President Trump is being so stunningly effective at controlling the border and pretty effective at going after illegals who are also criminal. But I do think in the long run, having somebody who deliberately comes in the U.S. just long enough to have a child, and then having had the child, maybe on a tourist visa, if you will, claiming now they have an American citizen in their family. My guess is, to the degree that that continues to evolve with modern transportation, that we'll probably revisit this issue. But first, we ought to see exactly what the Supreme Court says.
All right. Thank you, sir. Mr. Chairman, I yield back.
If you'd yield to me.
I'll yield to you.
I'll follow up on that briefly. So a diplomat's child is not a citizen, correct?
Specifically correct.
So a diplomat is here on a visa and is lawfully in this country, including the spouse, typically. Would an invading armies that comes with its spouses well, here occupying, let's say, Texas, would their children be covered under the 14th Amendment?
My reading of the debates about the amendment would suggest that you had to be here legally in order to be qualified to have a child who would become an American. See, you couldn't be here illegally. You couldn't be here in a situation where you would not be within American law. And I think in that sense, an invading army by definition is not here as part of the American law.
So it's a legitimate debate on the 14th Amendment where you'd be in and out.
I think it was a habit which grew up sort of absent-mindedly when there frankly weren't very many cases. And as it got to be a bigger and bigger issue, people began to say, wait a second, do we really think that in the 1860s, this is something they had in mind? And I think it's pretty hard to read the debate and conclude that they wanted birthright citizenship for non-citizens.
Yep. So now we go to the gentleman from Missouri next.
Excuse me.
Oh, I'm sorry.
Thank you.
Oh, you haven't gone yet?
No, I have not.
You sit so close.
I know.
The gentlelady is recognized for 5 minutes.
Thank you. It's interesting that we've returned to the birthright citizenship argument because I think the courts that have looked at this issue, several courts already, and have reviewed the debates from that time, found that they did explicitly consider the issue of non-citizens and who was in the country, and the court has considered it as well. But I think, Mr. Raskin, I could yield to you for a minute.
Well, thank you, Ms. Gallen. I've looked at this question too. I've gone back and I've read the debates. All of the explicit mentions I've seen were explicitly to reject the proposition that Speaker Gingrich just mentioned, the idea that somehow you wouldn't be covered. There was an exception talked about for the children of diplomats, but that was very much a discrete exception everybody identified. And one way of understanding this, of course, is that the African Americans for whom the first sentence of the 14th Amendment were core intended themselves all had parents and grandparents who were non-citizens, because the meaning of the Dred Scott decision was that you could never be a citizen if you were an African American or the descendant of slaves. And so the first sentence of the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof shall be citizens of the United States, was a direct overruling of Dred Scott and saying that all of these people whose parents were not citizens could come in. And there were specific questions on the floor about people from other countries, especially what were considered the Dread Chinese at the point. And there were very emphatic statements made that, yes, even the children born of Chinese non-citizens would be citizens. So I'm not quite sure what the speaker is referring to. If you've written a law review article on that, I would love to see it. But everything that I've seen, both directly in the debates and the law review literature, is completely counter to what he just said. Thank you for yielding.
Thank you. The committee's covered a lot of ground today, and I just wanted to return for a minute to some of the basic civics principles that were raised by this hearing and why our courts and an independent judiciary matter. Some of our colleagues and the administration itself have suggested that since Donald Trump won the 2024 presidential election, his actions and his interpretation of the law can't be questioned. Can you explain why that's a problem under our constitutional system?
Sure, I would say that sort of maybe the single most important core structural principle in our Constitution is that power be divided and that power check power, because too much concentration of power leads to tyranny. So all that we have seen with the rulings that have come down that have found violations of either statutes passed by Congress or provisions of the Constitution is the separation of powers working as intended. So the president having the sole and final authority to determine the meaning of laws, statutes, or the Constitution is just fundamentally inconsistent with the notion of separated powers that is, I think, the core of our Constitution.
I think we've also had conversations today about due process and how vesting all the power to determine what the law is and who is subject to it in one person or one branch leads to a slippery slope. We've heard today that the administration has deported someone who was not a Venezuelan gang member and in fact did not even have a criminal record. We know that in the past, the administration has deported citizens because they were not able to get a hearing to prove they were citizens. So this slippery slope becomes very real. Nobody here is saying that we shouldn't punish or deport violent criminals, but we are saying that you need to prove someone is a violent criminal before you can exert this kind of punishment on them. Can you talk about how that impacts every American?
Sure. Yeah, I mean, I just think that the only way that government can be sure and that all of us can be sure that they are targeting the right people for these harshest of punishments is by affording a modicum of process, right? That is the notion of due process. So making sure that individuals understand what is being alleged against them and have some opportunity to respond, that is just the heart of due process. And I do think that it's important that both the initial temporary restraining order issued by Judge Boasberg, that we've talked about a good amount already today, that was affirmed by a panel of the DC Circuit that included appointees of both Democratic and Republican presidents, simply sort of reaffirmed that core notion that a degree of process needs to be afforded to everyone. And that's not to constrain the ultimate ability of the president to enforce the immigration laws. It just suggests the Constitution needs to be honored while he does that.
I want to thank our witnesses. I'd yield my remaining time to Mr. Raskin.
Thank you. It seems to me that when Donald Trump was criminally prosecuted in New York or civilly sued in New York, everybody insisted on all due process, and he deserved it, and he got it. And even then, people still doubted the integrity or the veracity of some of the findings and the verdicts. And now we have people saying, no, we don't need any due process at all in order to, do X, Y, or Z to someone, and that just can't be right. Thank you.
Thank you.
We go to the gentleman from Missouri now.
Thank you, Mr. Chairman, and thanks to all the witnesses for joining us today. Speaker Gingrich, thank you for your testimony. You are a great student of history, in fact, a great teacher of history. And I'd like to recall the words of Chief Justice John Marshall, who famously said it is emphatically the province of the Judicial Department to say what the law is. I've never liked that quote because on its face it implies some sort of judicial supremacy, that judges are somehow supreme oligarchs, that they are like Moses bringing down the tablets from Mount Sinai. But I think Marshall at the time was presiding over what was famously called the weakest and the least dangerous branch of government in Federalist 78 by Alexander Hamilton. And I think Marshall, if he were here today, would say that, yes, the judges are the ultimate interpreters of what the law is, and of course it is the duty of the judges to apply the law in concrete cases before them. But we face a very different situation today. I believe we do have a constitutional crisis, as you say, a judicial coup. We have Chuck Schumer bragging about his 235, quote, progressive judges, his word, not mine, in over 100 cases, issuing injunctions time after time and time, his words, not mine, to block the Article 2 executive powers of a duly elected president of the United States. But I think, and of course we have the ridiculous decision of Judge Bozeman that planes ought to be turned back to aid vicious Venezuelan drug gang members. But an equally absurd TRO was issued by U.S. District Court Judge Brendan Herson in the P. Flag versus Donald Trump case. In that decision, Herson halted President Trump's January 28th executive order protecting children from chemical and surgical mutilation, which blocked taxpayer dollars from being used for sex change operations for children. This is an absurd and activist TRO, and the only reason such grisly procedures were ever covered by Medicaid is that President Obama's CMS decided they would be. There is no law passed by Congress that genital mutilation of children should be covered by Medicaid. So it stands to reason, to paraphrase Barack Obama, that what was done by the pen and the phone can be undone by the pen and the phone. But Judge Herson says no, he is above the law and above the Article 2 and the Constitution. So I believe we do indeed have a constitutional crisis. Mr. Speaker Gingrich, I agree with you that the No Rogue Rulings Act is a very good start. And I really encourage the Supreme Court to issue a ruling to make this very clear. Professor Shaw, in December 2024, Biden's Solicitor General Elizabeth Prelogar criticized the practice of nationwide injunctions. Then in 2022, or previously in 2022, Justice Elena Kagan criticized nationwide injunctions. In October 2023, speaking at NYU Law School, you criticized nationwide injunctions and what you called precision judge shopping, which seems to me is exactly what's being done against the executive action of the actions of President Trump now. And then in February 2023, in an op-ed in the New York Times, you said that the U.S. Supreme Court was at the time, quote, a genuine threat to democracy. But fast forward to March of 2025, and you're here today exhibiting enormous deference to not Supreme Court justices, but district court judges ruling dozens of times against the president's executive powers, and you're saying, well, they're just doing their job. They're getting it right, and President Trump has it wrong. Whereas it was the other way just a couple short years ago. Ms. Shaw, this looks awfully political on your part. Your response?
Thanks for giving me the opportunity to respond. I mean, I think what I was discussing in the quote that you mentioned was the problem, which I think is a very real one, of single judge divisions where plaintiffs can guarantee with 100% certainty that they will draw a particular judge, like Judge Kaczmarek in Amarillo, Texas.
And isn't that what's going on right now?
Not a single one of the 46 rulings that have come down against the Trump administration have been filed in single judge districts. It's entirely different. So I am not standing here saying that there is never abuse of the universal injunction. Reform, I think, is perfectly appropriate, but that's an entirely different problem, and that's not what's being addressed in the legislation. That's on the table.
Was the TRO and PFLAG versus Donald Trump correctly issued? And if so, where in USC 42 of the Social Security Act as amended with Medicaid, where do you see an entitlement for Medicaid coverage of sex change operations in children?
Sir, I apologize. I'm not sure the reasoning of the opinion. Many of these opinions have come down either on First Amendment or equal protection grounds, the TROs. So I would have to take a look at the reasoning in the opinion. But a temporary pause, which is what these TROs are, where a judge thinks there's a serious constitutional flaw with an order issued by the president, I do think is appropriate.
Temporary pause, just like puberty blockers. I yield back.
Gentleman yields back. We now go to the gentleman from South Carolina, right down the row.
Thank you, Mr. Chairman. Mr. Larkin, in your testimony, you talked about the history of nationwide injunctions and how this has not always been the practice in the courts up until the 1960s, and we've seen an escalation of nationwide injunctions by district court judges. How would you characterize the emergence of nationwide injunctions since the 1960s and its effect on the judiciary?
There are two things to keep in mind. First, the 1960s saw a rise in what is called institutional reform litigation, an attempt not just to win a case for a particular client, a particular John or Jane Doe, but to establish a rule of law that could be used in the whole category of cases to which it could possibly be applied, and then in a lot of others as well. So if you're doing it in a state, for example, you're not going to say that your client was the only one affected by unconstitutional prison conditions. You're going to sue the entire State Department of Corrections. Because what you want is to have one judge reconfigure the number of people in rooms, how the rooms are laid out, all of that. And so what you had judges who, in some cases, were trying to decide with hellish conditions that would have made Dante blanch, and try to figure out how to deal with that. And so it's not surprising that in some of those cases, there are different prisons. There were in Texas, Mississippi, Louisiana, we know them all, that were absolutely awful. And a judge under those circumstances is probably going to have to do more than just say, okay, well, you have to give this one client a better room. So what you saw was a development in this regard of judges expanding the reach of the relief that was being granted. That was part of it. Part of it was also
just sort of real quickly, just from a time perspective, do you think that part of this emergence of nationwide injunctions, particularly against the Trump administration now, I mean, the numbers are kind of shocking, is partly due to partisan nature of some judges on the bench?
Oh, I don't doubt that at all. I mean, if you take a look at the selection process, presidents tend to look for people who are going to rule in accordance with their views, whether you're on the right or the left, whether you're a Republican or a Democrat. I worked for Senator Orrin Hatch when he was the chair of the Judiciary Committee, and You know, if he was the chair under Obama, you would see one type of judge being nominated. If he was the chair under George W. Bush, you'd see a different type of judge being nominated. Different ways of looking at it is common among people, and people become judges.
Speaker Gingrich, earlier you talked about, obviously, that your support of certain congressional actions that would correct or rectify the role of the courts in these nationwide injunctions, but you also talked a little bit about that the court can self-police itself. I think with Mr. Kiley, you went into at least one metric on how that could be done, but what are your thoughts generally on how the Chief Justice, who seemed to kind of brush aside criticism of the courts and just say, well, you could just go through the appellate process, how could the Chief Justice rein in his own court?
Well, I suspect that Mr. Larkin actually knows more about this than I do. But my impression is that the Supreme Court has rather strong capacity to instruct district courts in a broad range of procedures. And I think that were the Chief Justice to basically preempt Chairman Issa's bill and say, this is how we're now going to handle it. I mean, the argument in this hearing, as I understand it, is really pretty narrow. It is that with over 600 district court judges, you cannot have them each thinking they're an alternative president, and therefore there has to be an alternative system. One system would be to block all nationwide rulings. Another system would be to have it appealed automatically to the Supreme Court. So a nationwide ruling immediately got a nationwide court looking at it and recognizing that the appeals process that the Supreme Court Chief Justice referred to is nonsense when you're talking about executive branch actions, because the length of time it takes to go through the appeals process is by itself destructive of the capacity to have what Hamilton called as an active chief executive. He said that the system will only work with an active chief executive. Well, you can't be an active chief executive if you have a whole bunch of Lilliputians tying you up. And this is a classic example of Gulliver and the local district judge who suddenly has blown themselves up in their own ego and decided, I too could be president, and I'll show you because I'm actually a superior president, because you have to obey me.
Right.
It's impossible to defend the situation.
And in that circumstance, sir, I know I'm over time here briefly, but in that circumstance, you have 600 presidents of the United States. Thank you, Mr. Speaker.
Thank you.
Yield back.
Gentleman from Wisconsin.
Yeah, I don't like being here today. It's a sad state of affairs because you don't like to have to clip the wings of the judiciary or say that sometimes we don't have to obey a judge's order, which is, I think, where this is leading. But we have a lot of judges who are reaching decisions that are just so completely out of line, and where a lot of these decisions are going to revolve around immigration and removing people. And the only reason this has become such a big issue is that we had a president who decided, to the degree which he could, he's not going to enforce the immigration laws of the country. So after you have completely irresponsible president and completely irresponsible judges, you wind up in the mess we are today. Now, just to clarify things, I'll ask maybe Mr. Larkin, Speaker Gingrich. Obviously, the country's been around now under our current Constitution for about 230 years, what precedents from the early part of our country indicate that injunctions should not be beyond parties directly involved in litigation? In other words, when Abraham Lincoln went to law school, what would he have thought about these decisions?
Well, of course, Lincoln didn't go to law school.
You're right, I was going to correct myself.
He read the law.
You're right.
But look, I've been around long enough that I remember talking with Jefferson. And when I talked to Jefferson, he said, you know, you simply can't have an oligarchy. And if you allow judges to be the final determinants, you by definition have left the people behind and established an oligarchy. I really think if you look at Lincoln, and if you read Fehrenbacher's extraordinarily detailed book on Dred Scott, Lincoln makes the Dred Scott decision the centerpiece of the 1858 campaign. And when Lincoln is very clear about this, think about Lincoln at Gettysburg, when he says government of the people, by the people, and for the people. He's not only referring to Southern slave owners, He's referring to the court. And he's saying, by definition, you cannot usurp the right of the elected officials. Now, if you read the Federalist Papers, it's very clear that the Founding Fathers thought the weakest of the three branches would be the judiciary, that it would always be cautious because it would always be subject to being overwhelmed by the executive and legislative together. And in fact, you all represent the branch the Founding Fathers most feared because they assumed that the people elected by the people would have the greatest power. So we just have to recognize there's a...
And we said they were wise.
Yeah, that's right. Look,
Did
I
we
think there are good reasons to fear the
Can I-
institution I once led.
Can I just add a short supplement to that?
Sure, I'd like to say, did this issue ever come up in the 1840s or 1850s or 1860s or 1870s?
No.
Okay, it was just assumed, it was understood at the time?
The law of equity was party-specific. If person one sued person two, the court would remedy whatever harm person one suffered. The court would not then go on and enter an injunction that tried to govern society. That was not the role of the courts. And the Supreme Court has even made that point more recently. They've said the responsibility to adjudicate a case of controversy is quite different from the responsibility to govern the society. The Lewis versus Casey, which is cited in one of my articles, makes this point. So it was not a component of equity in England or, as you put it, in the 1840s, 50s, or 60s. It happened only much later.
Okay, now we're never supposed to, they tell us you're never supposed to ask the Democrat witness, but I'll break with my stuff. Ms. Shaw, what do you think is the strongest example of a case, say, before 1870, in which a district court tried to come up with a ruling that affected the whole country?
We don't have examples that are of the sort of nationwide injunction that we know today. I don't think that's really in question. There's been an enormous increase. The scholarly debate about how kind of how historically grounded this is, goes back and forth, but it's either about a century old or a little more, but I don't think there's much suggestion that there were injunctions of this sort in the early
Okay, that would
the
be an
19th
indication
century.
that under our Constitution, our forefathers never dreamed we'd have these type of rulings come from somebody who just, it comes from an individual district. But we'll ask, I could tell Speaker Gingrich wanted to get in one more swing here, so we'll let you get in the swing and then I'll.
Look, what we have seen over the long sweep of American history is a gradual, steady increase in the self-esteem and power of lawyers. Marbury versus Madison is totally misrepresented. The fact is that Marshall was terrified of Jefferson, knew that the Jeffersonians would gladly wipe out the court, danced around. It's not revisited until Dred Scott, and Dred Scott's a disaster. And so you really have a long period here where judges didn't think they had the power to define for the country how the country should behave. And what we're living through, and I'm very sympathetic to the agony on the left, because this is if you have Jefferson, Jackson, Lincoln, FDR, and Trump, this is the fifth great cycle of a profound challenge to the existing order. And obviously, these kind of periods are very painful, and they're very dangerous, and you got to work your way through them. And I think this is one of the examples. You have a group of people, well-meaning, I believe, but ideologically deeply convinced that they have the power to overrule the President of the United States. And now the country has to make a decision. Do we, in fact, have alternative presidents in the form of district judges or not? And the country, I think, will overwhelmingly decide that that's impossible. And so, but this is a classic historic, this is what the Congress should be about at its best. This is a classic historic discussion on both sides of how we retain a balance of power between the three branches. And I think that's where we are.
Thank you. We now go to the gentleman from Texas who's been patiently waiting.
Thank you, Mr. Chairman, and thank you to the witnesses who are here. We discussed it a little bit earlier, but I'd like to put a little bit of a finer point on it. In the 117th Congress, then Chairman Jerry Nadler, as well as Hank Johnson, introduced the Judiciary Act of 2021, which would have increased the size of the Supreme Court from 9 justices to 13. That bill had 59 Democrat co-sponsors, and they were so convicted that the size of the Supreme Court should be 13 justices that they then reintroduced the same bill in the following Congress and received 65 co-sponsors. So I am looking forward to my colleagues on the other side of the aisle reintroducing that bill this Congress as well. We hear a lot about bipartisanship, and I'm sure you can get a little bit of bipartisan support for that when you do. But with that said, Mr. Chairman, civilization is a very fragile thing, and in the Western world, particularly in the United States, it's been unraveling as the left and their allies on the courts have intentionally and deliberately facilitated the mass migration of criminal illegal aliens into our communities. These are people who are murdering and raping and pillaging American citizens on American soil, a country that was once the zenith of civilization. America increasingly resembles the third world and is reverting to barbarism, as Ms. Romero's testimony so poignantly underscores. And instead of fighting for the preservation of our communities and the integrity of our nation's sovereignty, our colleagues on the other side of the aisle want to keep alien terrorists within our borders. And it's so many times district court judges are leading the charge. And I think that Judge Boasberg is an excellent example of that. Mr. Speaker, thank you very much for being here. It's an honor to be able to speak with you and ask you questions. I look up to you a lot. Could you explain how much constitutional and legal authority does Congress have to oversee lower courts?
Well, there's virtually, if it acts with the executive branch. I mean, the part of the theory of Montesquieu's spirit of the law, which is the base of the Constitution, is that you have these 3 bodies. Any 2 outvotes the other one. So in a very real sense, the Congress and the judiciary could take on the executive, or the judiciary and the executive could take on the Congress. There's a constant revolving. President Jackson made the argument that, in fact, each of us, every elected official, has an equal obligation to enforce the Constitution. And he refused to accept the idea that the court could instruct him. I mean, they very blatantly just said, glad you think that, I don't. And then Taney, who was his attorney general, who defended that, ends up as a Supreme Court justice, in many ways leading to the Civil War by his decision in Dred Scott. So I think you have every right, if you read the Constitution itself, you create lower courts. I mean, the Supreme Court is superior in the sense that it's the one thing in the Constitution you could not eliminate except by constitutional amendment. Mm-hmm. But everything below that is a creature of the legislative-executive agreement. I'm assuming here you're not going to try to override the president, but theoretically, the Congress could decide, and if it had the votes in the House and Senate, you can override a president.
Right.
So the courts are actually much more subject to the policing of the elected officials of the United States than they think they are, and that's because for about 3 generations now, law schools have taught this mythology of legal supremacy based on the judicial branch alone. It's nonsense. It's one of 3 co-equal branches, and it is the weakest of the 3, not the strongest.
In terms of enforcing that oversight, putting aside whether impeachment is the most expeditious or prudent means right now to oversee the courts, do you believe that it should be at least considered as an option to remedy blatant or flagrant judicial overreach from district court judges?
Well, I think that Chairman Issa has exactly the right first step. I mean, look, we're in the middle of such enormous change that this will strike some of you who know my career as sort of unusual. I'm actually now in a period of thinking incrementalism may be pretty good because we've actually set an enormous shift strategically. And now we need to spend a little bit of time cautiously, so I don't want to overreach, which you, I mean, theoretically, you could abolish the district judges. You have that power if the president agrees. But that would be an enormous jump. And I think the country needs to educate itself, and frankly, the judges are going to get educated. If they see the legislative branch seriously moving, I mean, it's one thing to have the president say something, from the bully pulpit. It's another thing to suddenly see laws moving and realize, if we don't pull back a little bit, this could become uncontrollable.
Yep.
I'm hoping, that's why today I've repeatedly talked about the opportunity the Chief Justice has, because I really hope he'll realize he has the best, easiest, least disruptive solution.
And for the record, I agree that I think that Mr. Isa's bill is an excellent piece of legislation that we should all be able to get behind.
As a freshman, you're going to go far. The gentleman from Washington is recognized for 5 minutes.
Thank you, Mr. Chair. Thank you to our distinguished panelists for this insightful testimony and what's been a long day. Mr. Speaker, it's a real honor to be able to ask you a few questions. When you're a freshman in this body, you see a lot of portraits on the wall, and frankly, you don't know who a lot of the people are, but I think the American people always remember you in the mark you've left on this institution. The question I have for you is just to comment on the situation the American people find themselves in, because I think this is a very dangerous and perilous time for America, because I think the American people think the fix is in. And you talk to the average person in my district, and they look at a situation where over 12 million people came into the country illegally, and there was no remedy to stop that procedurally from their elected officials. And now they look at a situation where after they had an election, they had a president that clearly campaigned on this issue, and they look at dangerous gang members who spread fentanyl that's killed over 100,000 Americans, more than died in Vietnam, more than died in the wars in Iraq and Afghanistan, and they say, well, let's get these people out of here. This is what we just voted for. And yet now there's a system where the one judge or a few judges in a certain area after judge shopping can stop. So they look at the situation and say, is there any remedy to this? I mean, what is the future of the republic if what they just voted for is something as egregious as dangerous, hardened gang members from a foreign country, in the country legal, spreading a deadly drug that is killing over 100,000 Americans, and they say, well, how is this supposed to work? So what would be your comment to these people?
Well, 3 quick things. First, I run a project called the America's New Majority Project. And if you ask the American people, do you think the system is corrupt? 82% say yes. Now that's really dangerous in a free society. I don't care what your ideology, what your partisanship is. When more than 8 out of every 10 of your fellow Americans think the system's corrupt, you have a deep challenge to somehow break through, really on a nonpartisan basis. Second, President Lincoln once said, with public sentiment, anything is possible. Without public sentiment, nothing is possible. And I think it's very important for every judge who thinks they want to impose themselves on the president to ask themselves, are you putting the entire judicial system in disrepute? Because if the country sees really sort of, by the standards of most Americans, fairly radical positions being taken by judges, blocking what is the clear will of the American people, not just the president, I think that it literally puts the entire underlying system under enormous stress and leads to popular dissatisfaction in a way that's very, very dangerous. The stability of the system ultimately requires that all of us find a way to work together, to behave in such a way that people no longer think the system's corrupt.
And Mr. Speaker, just finally, you referenced Thomas Jefferson, one of our founding fathers, one of the founding revolutionaries of this country, the author of the Declaration of Independence, in your opening statement. I was able to visit the White House for the first time last week and got to meet President Trump there. And as we came in, we exchanged some pleasantries, and there was a kind of a humorous moment because neither of us knew quite what to do because staff wasn't telling us. And as we had this kind of moment of silence, and he said, well, can I show you the Declaration of Independence? And he turned around and it showed it to me that was on his wall, and he was very proud he just had it installed. And so it was kind of a fun moment, as you can imagine, for any American citizen, particularly a freshman member Congress. But I hear you loud and clear, and I hope on what you think is the best remedy at this point is that Chief Justice Roberts steps in and brings some clarity and some sanity to the craziness right now. But if he didn't, and President Jefferson were sitting in the White House or the president right now, what do you think President Jefferson would do if Chief Justice Roberts wouldn't step in and help this issue?
You know, the Jeffersonians as a group were bitterly anti-judge. The number 2 demand in the American Revolution, after no taxation without representation, was their hatred of the British judges, because they were appointed by the king, served at the king's convenience, and were seen as the oppressors imposing the law of a foreign government on the American people. And Jefferson had grown out of that tradition. Jefferson's probably the most radical of the founding fathers. And the Jeffersonians ran essentially on cleaning up the judiciary. This is why the whole thing with Marshall is such a wonderful example of a sleight of hand. Because if you look at the Judicial Act in 1801, after they lose the election, the Federalists passed the Judiciary Act of 1801, which creates judges, many of whom were being appointed literally the night before Jefferson sworn in. So they were called the midnight judges. Well, the Jeffersonians thought, we're not going to have this. So they write the Judiciary Act of 1802, and they wipe out, as I said at the beginning of my statement, they wipe out, I think, 16 of them, 14 of which were actually occupied. I got into this because a good friend of mine who's a great lawyer said those must have been vacant, because after all, it's a lifetime appointment. No, we went back and pulled up the biographies. These 14 guys had to go out and get a job. I mean, they were gone. And so I think Marshall knew, you push Jefferson very hard. I mean, a guy who buys half a continent, sends the Marines to Tripoli, you really want to play this game? And they didn't. I mean, he was if you read Marbury versus Madison, it's a brilliantly clever device in which he says, we really have this authority, but you don't have to worry about it because we ain't going to give it to him. So, you know, Marbury doesn't get his writ. Well, so he tweaked Jefferson, but he knew if he tweaked him too much, he would probably have replaced the whole Supreme Court. I mean, the Jeffersonians were very tough about this stuff. I think Jefferson also was very practical. And I think what Jefferson would say is, you've raised the issue, you've begun to get the country aware. You might consider as a first step, Chairman Issa's bill, there may be, I'm not suggesting this, but I'm responding to your question. It may be speculatively at some point that the most radical and dumbest of the decisions could lead to interrogatories to the judges, first in writing. It might even be conceivable at some point that the judges might be brought in under oath to explain what's the Constitution. I mean, how did you think of this? What's the constitutional basis? Why are you doing this? I mean, there are many ways one could pursue this. My hope is that the comments we've made here today will in fact move the Chief Justice to eliminate the problem and to get back to a situation where no single district judge is an alternative president, and where we can have greater respect for the court system because the court system has greater respect for us.
I thank you all. It's been a long day, and although my closing statement I'll read in a moment says this will be in writing, just to make it easier for all of you, there are approximately 8,000 petitions to the Supreme Court every year. Over the last 3 calendar years, the court has accepted 68, 62, and 62 of them. We've heard a great deal today about just appeal, just go through, on now what's clearly going to hit over 100 national injunctions, all of whom would, according to Chief Justice Roberts, have to go to him through an appeal process. Even with Speaker Gingrich's suggestion, that would be 100 additional cases potentially in a year going to the Supreme Court. In writing, because it has been a long day, to the extent that any of you want to opine on the question of the burden to the court that comes from these many, many, many national injunctions, because we've talked about my bill here quite a bit today. We've also talked about impeachment quite a bit today, and you're all welcome to opine on that in written. But I think it's important that we also ask a lot of functional questions. Ranking Member Johnson and I, we oversee the courts. We've moved again in this Congress on a bipartisan basis, to add 66 new judges at the district level. But we all have to be concerned of caseload, of how do we get the right number of cases, how do we get them to the judges, how do we get good decisions, and ultimately the burden that flows up to the Supreme Court. So, as my script now says, this concludes our hearing, and I want to thank our witnesses, and I would ask that all members have 5 legislative days in which to give additional written materials for the witnesses, along with other material, and would ask that the witnesses be willing to respond to those if they receive them. And before I gavel, Ms. Romero, you weren't asked any questions to speak of today because you weren't a constitutional scholar, but I'll leave to you the last word.
I'm worried that all the outrage following the illegal immigrants' rights and their right to be here, and they could be good people, and we need to have them properly vetted before we get them out of the country. Where was all the outrage before you let them in? Where was all the outrage when my video happened? You guys save your outrage to when it's convenient to fight a president who's trying to make a positive change in the country. Where was all your outrage when I needed your help? Because I feel like you guys have lost the plot, and you're allowing harm to come to Americans in the pursuit of stopping President Trump. And I don't think that that's right, and I don't think that it's fair, and I don't think in the next election it'll stand.
Thank you.
Mr. Chairman.
We stand adjourned.